I'm calling the meeting to order. Thank you for your attendance and participation. The purpose of the public hearing is to gather information from the public to help the commission formulate recommendations. In order to ensure a fair and orderly meeting where everyone can participate, the commission requests that you act respectfully to everyone in attendance and follow the public hearing procedures. The chairperson will call the public hearing item. The planning department will present the staff recommendation. Commissioners may ask questions of staff. There will be a presentation by the applicant or representatives. Commissioners may ask questions of the applicant. The chairperson will open the public hearing. The chairperson will call for public comments from persons in support of the items, followed by persons in opposition. The applicant will have the chance for rebuttal comments. The chairperson will close the public hearing. Commissioners may ask questions. There may be discussion and take action. Speakers must speak from the podium and state their name and address for the record. There's also a sign-in for you. The chairperson reserves the right to establish a time limit for all speakers to ensure that everyone can speak. The designation of a spokesperson for groups sharing a common point of view is encouraged. All comments and questions will be directed to the chair from the podium and not to the applicant, staff, or to the audience. When the hearing is closed, additional public comments are not permitted. We'll now have roll call.
I'm acting as the roll call attendee today and will be taking the vote. So Jeanette Johnson.
Present.
Chad Gearhart.
Here.
Rosa Cavazos.
Here.
Terry Robinson.
Here.
Dan Bryan.
Here.
Myron Lenwitter.
Here.
And then the last position is vacant, so 6 are present. We do have a quorum.
Have there been any communications from the public to staff in regards to what we're hearing?
We haven't had any communications.
Thank you. Have there been any ex parte communications by members of the commission? Seeing none. Is there any conflict of interest by members of the commission? All right, then the next item is election of officers for this year. Are there any nominations for chairperson?
I would nominate Jeanette Johnson for chairperson.
I would second.
Okay, so we had a motion by Chad and second by Rosa.
Are there any other nominations? I think I'm supposed to ask it 3 times. Are there any other nominations? Any nominations? Then all in favor of electing Jeanette as the chairman, say aye.
Aye.
Thank you. Opposed? And vice chairman, are there any nominations for vice chair?
I would move to elect Chad.
I would second that.
It's been moved and seconded to nominate Chad as vice chairman. Are there any other nominations? Any nominations? Then all in favor of Chad being elected to vice chair, say aye, please.
Aye.
Opposed? That motion carries. Congratulations to us.
Okay, so Jeanette, you can continue on then.
All right, first is CU 2501 SCF Real Estate LLC requesting a conditional use permit to establish a demolition landfill and recycling facility on property zoned RR1 Residential Reserve District located at Southwest 25th Street in Menoken Township.
Okay, so Hareem has been the one working on all of these projects, and so I'm gonna turn it over to her, and she will go through item number 1 for you.
All right. Item number 1, this is an application that seeks approval for a conditional use permit to establish a demolition landfill and recycling facility on property zone RR1 Residential Reserve District. It is located on Northwest 25th Street, and it consists of about 36.05 acres. Next, we have the general location showing the site within the county, and you can see it as the blue star. Here we have the vicinity map. The site is outlined in green. 13 letters were sent out to property owners within 1,000 feet. No public comment has been received. Here we have the site plan. The previous owner used the site as a borrow area for the Highway 24 realignment project around 2014 as a dumping ground for construction materials. This use was not permitted, and the current owner is working to bring the site into compliance. All of the restrictions that exist within the RR1 will remain, with additional restrictions as set forth in conditions as expressed herein. So staff recommends approval of the requested subject to the following conditions. 1, obtain a solid waste processing permit from the Kansas Department of Health and Environment Bureau and Bureau of Waste Management. 2, prior to commencing any work, ensure copper or fiber optic lines along Northwest 25th Street are located. 3, operating hours are limited to Monday through Friday from 7 a.m. to 5 p.m. All other activities must adhere to the statement of use dated December 19, 2024. And that concludes item number 1.
All right. Do the commissioners have any questions of staff?
How is this property, if it wasn't permitted, how were they allowed to function as this dumping ground for KDOT?
Well, we didn't know, nobody had called it in, so they were just using it.
It happens frequently where land gets used in a manner that they don't necessarily know. The borrow pit was from quite a few years ago, and it was a state project. The prior owners were ham operating on behalf of that KDOT project, and it was probably assumed that it was an allowable use. And several years had passed after the project had ended, and I believe that we had received some questions about it, but then about the same time, ownership changed. And with the new owners wanting to use it for a different purpose than a borrow pit, they had reached out to us, and we had communicated with them that it needed a conditional use permit.
Any other questions? All right, would the applicant like to make some comments?
Thank you, Madam Chairman, members of the commission. My name is Vernon Jarbo. I'm with Sloan Law Firm in Topeka, here on behalf of the applicant. Today, with me, Roger, sitting closest to me, is the manager for SCF, and will be managing this project. Next to him is Josh with SBB Engineering, and they've done the work that you've seen here. We recognize the 3 requirements that staff has placed on the property, and we're comfortable with everything that was said by staff in terms of their presentation to you. We believe it will actually be a better use of the property going forward than sitting there with random trucks dumping whatever they felt like dumping when they went by and saw an open space that was ungated. So we have secured the site. And done the things necessary to restrict other people from random dumping, and would intend to go forward with our operation. As I said, Roger will manage the facility going forward. It's basically to gather and recycle asphalt, concrete, and clean dirt, and stuff like that. Some of the material gets recycled, some of it that's not usable for those purposes, if it's clean, would go into the hole to fill the hole up eventually. So that's our intended use. If you have questions, I probably don't know the technical answers, but I bet these guys do.
This is probably more for staff. What is the length of this CUP? Is there a length?
Once a CUP is approved, unless you put a condition on that it stays with these owners, it runs with the land.
with the land.
So if they sold it to someone else, the new owners would be subject to the same conditions of the CUP. There is an abandonment time frame within our regulations at this point, where if it's not used for the purpose that they have asked, it can be abandoned after a period of 24 months, after 2 years.
Did the township have any comment? I mean, I assume the township was notified. Any,
Yes, no.
no comment on the road or anything? Okay.
I have a question. Is there any concern about not being open on a Saturday morning, or could that possibly come down at a later time that you would decide to be open on a Saturday?
Certainly it could be, but as I understand it, materials will all be brought in by either ourselves or contractors working with us. So we're able to control that.
Okay.
It's not like a public facility. Am I right, Roger?
Vern, also once the pit is filled and covered, will it still remain a recycling site?
Well, if we're that successful, yes. Recycling, this is what they try to do, is they try to make reuse of all these materials that we see that are dug up and torn down on various, typically road, but other types of projects.
And then the unusable materials would then be hauled off to another site?
Correct. Told you I didn't know. Thank you.
Mhm.
Oh, I'm sorry.
When did they purchase this property?
Was it 24 or 23? I think you bought it just last year, didn't you? Yeah, I don't either. Not very long ago. We haven't really done anything to utilize it because we figured out that what was happening there wasn't permitted at all. It's one of those things, when I first looked at it, I've told a lot of people this, including Joni. When I just looked at it, I said, borrow pit by KDOT. I just knew what it was, because this is the kind of work I do, and I know what KDOT does, which is whatever they want to do.
So they knew when they were coming in and purchasing this property, the potential risks that were involved?
I don't think they actually understood that it wasn't permitted at the time they bought it. I don't think they did that homework until after they owned it.
So how do we know, as the general public, how do we know that there's not toxic material out there or stuff that shouldn't be in there? Has there been any testing or anything that's part of the process for the solid waste processing permit? What guarantees are there that there's no contamination out there?
I don't know that we have a guarantee there's no contamination. We're not aware of any, and there was no material at the site. The material that was at the site, when I first looked at it, I mean, there were piles of various kinds of things that were stacked around, but it was just exactly the same stuff that SCF does, which is deal with soil, broken up concrete, broken up asphalt. That's what was there. And so we haven't seen any evidence of anything else. I mean, there's no, like drones of anything, or there's been no facility there, no building of any kind.
But
If
but-
staff can, maybe if staff can interject just a little bit so that we can explain how we got to where we're at. We received a complaint from a neighbor in regards to dumping on the property. We reached out to the owners to say, hey, we've looked at this site and we see that there's no permit, what is being dumped? And when I say we got a complaint, it actually went to our environmental health department. So the environmental health department had reached out to us to see whether or not there was a conditional use permit. We found that there was not, and so we reached out to the owners and they contacted us. The dumping was something that was not their people that were doing it. It was other people randomly coming onto the property and dumping stuff. After we reached out and notified them, they put up they already had a gate up, but they put additional blockades around the property to keep people from being able to get on. Because what was happening is, at least one time, a truck went around the gate onto someone else's land and into the property to dump the material and then left. We were only aware of the one situation of a dumping being done. We don't know if it happened on other circumstances that were not noticed. But environmental health was involved and they had some of the material, and I don't believe that there's been any concern at this point that anything dumped on the ground has been harmful. We just wanted to make sure that the new owners brought it into compliance with whatever needed to be done based on their actions.
How many years was it where there was just an open gate and anybody could dump anything?
We don't know, 10 years maybe? I mean, the KDOT rework was probably in 2017, 2018. And prior to that, it would have been farm ground, and then it was, KDOT used the land, they came and dug the dirt out and used that dirt to build up one of the on-ramp, off-ramps of the highway that was just across from the property. And then the property continued under the same ownership for several years prior to the current owners taking ownership.
So what happens if KDHE goes out there and in the process of getting this permit, they find something detrimental, then what happens?
It'll have to be cleaned up. And kind of a big picture analysis. There's a law out there called CERCLA, Comprehensive Environmental Recovery Liability Act, something like that. And basically it says that if you have polluted the ground or are the owner of polluted ground, you have to deal with it. So if that were to happen, then we'd have to deal with it. Now, there might be claims back against previous owners, KDOT, and, you know, whoever might have been using it before us. But, I mean, is that a possibility? Yes, that is. We haven't seen any evidence of it at this point.
Good, yeah. Do you plan on, scale house, any other improvements? Is any of that?
Not at this time, no.
Okay, mobile crushing equipment, I assume, for your processing?
Yep.
Yeah. Fuel storage on site? No fuel storage no, just be delivered to site? Okay. Is there anything we need to be talking about a finished elevation of this site? If they were to fill the borrow back in, you know, I guess, I see on here that they've said 30 feet stockpiles. You propose not to have your stockpiles over 30 feet. As that site was to fill in, do we care about finished elevation?
We did not consider finished elevation mainly because this isn't like a landfill where you're gonna continue to bring trash in and build it up and up. Right now, there's a fairly substantial amount of hole that could be filled, and I think that it's gonna take quite a bit to bring in and fill. And even to that degree, whatever's stockpiled and filled on there would be clean rubble and would fall under the permit that would need to occur with KDHE. And so if they have any sort of height requirements, but we did not consider that.
Should we condition this based on their 30 feet stockpile? Is this part of the conditions? I mean, they've proposed 30 feet.
Anything that falls within their proposed,
Proposal.
is, as
Is part of
option
it?
number 3,
Yeah,
it would be
send it
subject to
back
those conditions. They have to adhere to that statement. And so then if they want to go beyond or modify that, they would, excuse me, have to come back to our office for either a minor or a major amendment to the conditional use permit.
Okay.
Are there any other questions for the applicant? Thank you. We'll now open the public hearing. Are there any comments from persons in support of the item? Are there any public comments from persons in opposition to the item? If you'll go to the microphone, please, and sign in.
My name's Dennis Moeller. I live at 5530 Northwest Boynton, which is down the road. I used to own the land where they put the pit in. I don't really have a lot of opposition to what they're doing. I just had some questions about how it's going to affect our ability to farm around it, if that's changing anything. I did also, over the years, they've been dumping a lot of asphalt and a lot of stuff in that groundwater. So I'm just kind of curious on how that was testing out. They're still pumping dust or whatever from the asphalt plant, and they're come down there with a truck and pump it in the water. So it's just mostly a question on how we're going to be able to farm around it, if that's changing.
What do you mean they're pumping dust from the asphalt plant? What does
They
that
come
mean?
down there with it's like a tanker truck, and they run a hose from the truck down there with a pump that's pumping that dust down into the water. They've been doing that since it's been open.
Asphalt dust?
Asphalt plant.
Yeah.
They previously dumped quite a bit of asphalt, just loose asphalt down in there too. From what we've seen, just, farming around here. I know made it a little inconvenient when we put the gate up and the concrete barriers, because I used to drive around there to get to the other side. There's only, I think we're farming 10 acres around it. It's going to belong to us. Otherwise, I really, the landfill, or if they get the permits and everything, I don't have it, really any problem.
Can I ask a question of him? Do you still have access to your farmland?
Yes, I can come in from the east end, kind of run along the, you don't have the map, but from the east end there.
You want to
We-
pull that, the map
do.
up again, the
This one?
vicinity map?
The
There
railroad
you go.
has a.
Go a little bit further back.
Okay, here, there we go.
We come in along this side, to get up here. We've always just kind of farmed this little strip along there.
So are you farming the land that is on their ground, or, okay,
When Hams did it, they said, they thought it was a good idea for us to keep the weeds down. The railroad has a right of way that I gotta rent along here, along the edge too. I think there's 200 feet from the railroad. I guess the railroad right of way.
my recommendation would be that after the meeting, you connect with the owner so that you can work out how that would work in regards to farming, if new owners, so that they know who it is that's handling that and if they're gonna continue to have you farm that.
All right, that's kind of was what I was looking to say.
Thank you for your comments and questions. Would the applicant want to respond to anything that's been said? You don't need to, but
Actually, we were curious about who had been farming it, we didn't know, so. Now we know, and we definitely would want to talk to him. Not saying we're gonna change any relationship, but we did want to know, obviously, who's using the land.
all right, we will close the public hearing. And are there any other questions or discussion among the commissioners? Everybody got their questions answered, and, all right. The chair will entertain a motion on this request.
I would move to approve the request, based on the staff recommendations.
I'd second that.
All right, it's been moved and seconded that we approve the request subject to staff's conditions. Want to call the
Okay.
roll?
Terry Robinson,
Yes?
Dan Bryan,
Yes.
Jeanette Johnson,
Yes?
Myron Lenwitter,
Yes.
Chad Gearhart,
Yes.
Rosa Cavazos.
Yes.
With a vote of 6-0, this item will be heard in front of the Board of County Commissioners. What is this month? This is February 10, so it'd be heard March 13th at the Board of County Commissioner meeting.
Thank you very much for your time.
We will move on to P 2501, the Water District Number 2, Tower 1 subdivision preliminary and final plat.
All right, item number 2, this is an application that seeks approval for the preliminary and final plat approval to establish a legal built site of subdivision known as CRWD Number 2, Tower 1. It's located at 9525 Northwest 46th Street, and it consists of 0.86 acres. Here is the general location of the site, as you can see with the blue star. Here we have the aerial map showing the site in the yellow, which currently has the water tower. Here we have the preliminary plat, and then we have the final plat. Staff recommends approval of the preliminary and final plat of the CRWD Number 2 Tower 1 subdivision, subject to the following conditions. 1, execution of additional dedication of the site as a public right-of-way on Northwest 46th Street as required by the Shawnee County Public Works Department. 2, notes to be included on the final plat. 1 is the Rural Water District Number 2 is permitted to maintain an east-west drive within the dedicated right-of-way until such time as improvements are constructed. At that point, the RW Number 2 shall cease using the east-west drive and provide an alternative entrance at its sole expense. The second note is to have the water main currently situated on the private property, which will become part of the county right-of-way through easement, acquisition, or dedication will not occur. Relocation costs for RWD Number 2. And then also, a building permit will not be issued until the minor amendment to the conditional use permit site development plan is approved. And this concludes item number 2.
All right, thank you. Are there any questions of staff from the commissioners?
Can you explain a little bit more about that east-west road? They can only use it for so long. I guess I got lost on that part. If you go back,
Okay.
one slide, that, the bottom bullet,
No,
the east-west drive is dedicated right of way. Is that private property?
Mm-hmm.
let me see.
So they have a drive on their property right now, and so,
Oh, which one?
right here.
Okay.
So when the building is built, They're gonna put in a drive from their entrance and go along the front and down to the building. But if in the future, road improvements are made where they would take over any of that road right away and need to, take over the land where that drive is at, then that drive would have to be moved.
Okay.
But until that time, which is an unknown factor at this point, it may or may not happen in the next 20, 50, 100 years, we just don't know.
Any other questions? Would the applicant like to make a presentation?
Good evening. I'm Ben Kramer with Kramer Consulting, here on behalf of the applicant, Consolidated Rural Water District Number 2, Shawnee County. I do have with me this evening the Water District Manager, Riley Reese, and there is a board member present with us this evening as well. So we brought this case, what they were looking to do is put a building up. So we met with staff about doing a conditional use permit, and got into that, to do the conditional use permit, that we'd have to plat the property. So we went back and started doing the platting. Some of the things that were discussed at our meeting were one of the main things was the additional right-of-way. And because the road there is constructed south of the section line, completely south section line. Currently, the road's out of right-of-way onto the Water District's property, and so we're gonna, we're agreed to give some additional right-of-way. One of the questions that we have is that staff recommends approval, granting that they, on the condition that we grant or we give additional right-of-way. One of the questions we have is, we're showing additional right-of-way, 25 feet. Is that what we're looking for? Is that the additional right-of-way that the staff is looking for? So that's one of our questions. And if that is the case, then if what we're showing, the 25 feet, then the district is in agreement that they would give that condition, that they would give that additional right-of-way, that 25 feet. The other condition, I think, is just that they can maintain their right-of-way and that, or their road, and that at such time that the county does widen the road, they would do away with their road at their expense, and it would be the county's expense to relocate the water lines and such, because they're in private easement today. So if we could just get a clarification on that additional right-of-way.
So the additional right-of-way that was requested by the Public Works Department was 45 feet.
So it was 45 from what point, though?
I believe it was from the center line.
From center line of
The
existing
road.
right-of-way, or?
The center line of the road. So an additional 45 feet from the center line of the road, whereas you're showing, I believe, 25 feet from and you had inquired with Ms. Perez in regards to being able to stick to the 25 feet, and Shawnee County is asking for the full 45, and so we were giving you the option to present that tonight in regards to your request for the 25 versus the county's request for the full 45.
Okay. So, I don't know, can I hand these out to the
Yeah,
commissioners?
absolutely. Absolutely. Just make sure that if you have copies, that we end up with one, so that we, unless it's part of the record
What
already.
this is just a preliminary plat with that aerial overlay, just so you can see where that road is located at.
Thank you.
I do have one other copy.
Okay. Before the end of the night, if I have one, that's fine.
Thank you. So I just wanted to show you where the road is currently in relationship to the dedicated right-of-way that we're dedicating, or showing to dedicate as a 25 feet, which is just north of that proposed gravel drive. So one of the reasons that we're looking at this is that there's a water tower on the site, and periodically, every 20, 25 years or so, that tower has to be painted, sandblasted and painted. Sometimes there's equipment that comes on and off of it. There's sandblast trucks and water pressure tanks that have to go on this site. To give any additional right-of-way over that 25 feet starts to hinder their operations here. There's some safety concern with when they're painting, you sandblast, you paint. If that road actually gets close to their property, that's another safety concern that they have to be to protect the public of falling debris, paint, overspray, those sort of things. Also just the general maintenance when they're on top of this tower, if something falls off the tower and that right-of-way is, I'm gonna say, I don't know exactly how far it would be, but 20, 25 feet away from the tower. Could something actually bounce off the tower and hit somebody that's in that right-of-way that at present it wouldn't, because that right-of-way doesn't come back that far? Riley might have something to add to that. I don't know if you do or not, but.
Yeah. We have several antennas on top of there. You guys realize that all of the internet, we have all these satellite antennas or radio antennas on top of the tower. And in order to get them up, this is a spear, it's a big ball up on top of a single leg. And it goes out there, I mean, the shadow of this thing will be in the road right away. If we give that full right of way. If we try to get satellite, or not satellite, but these antennas up and down off there, they can't pull them straight up and then drag them over the ball. They have to go outside of the fence to get those on there. And anytime that we take material in or out of this area to put in this storage building, we'll be parking in the street in order to try to get in here. And I don't know if you'd ever have to lay this tower down to work on it, if anything had ever happened like that. I mean, we can do that right now, but if we put this additional on there, I don't think we'd be able to do it. If you look at the cost to the county when you build this road, if you build it if you added your extra lane, because I understand they're looking for 3 lanes and sidewalk, if you would build that on the north side of the road, in the mile from over at Hodges Road to Hawk Road, you only have to move 2 driveways and 2 water meters. If you build it on the south side where we're given this easement, there's 11 driveways, 11 water meters, water main that goes across 46th Street, water main that runs down along the side of 46th Street. It'd be considerably more expensive to build on our side than if you put it on the other side. And the water district bought this property years and years ago, and it just seems unfair, and I know the world's not fair, but it seems unfair to me that 100% of this right-of-way is on the water district's property and not 1 inch of it on the guy on the north side of the road. And I guess that's all I got to tell you.
So, anyone, commissioners have any questions for us?
I think the big question is when do they expect any kind of road expansion in that area.
Can we get any kind of comment from Kurt on this? Yeah.
Absolutely, that's why he's here.
Okay.
Kurt Niehaus, Director of Public Works.
Oh,
Kurt House, Director of Public Works. You know, that's a good question. And if I had to be honest with you, I don't think that 46th Street out there will probably be improved within 30 years. But at some point it will. And we need right-of-way when we modernize a road. You talk about cost, sounds legitimate, but it's also very costly to move a road. When you widen a road, you basically take that existing footprint and you extend it out. Here, we're taking all that embankment of that existing road and we're moving it north. So you're moving a whole lot more material. You're having to compact that material. So the cost of any project where you're moving the center line of the road is significantly more than if you're widening or building on an existing footprint. Not only that, but without knowing what the grades are in relation to the adjacent property, if you're in a cut or a fill area, I think you can see if you move a road, it gets very expensive because you have to move that embankment, a large volume of material from one location to another. So typically when we improve a road, we improve it on the existing right-of-way. You might ask, well, how did that road get so far off the section line? I'm sorry. Could have happened 200 years ago. Could have happened, not 200 because Kansas probably didn't exist then, but 100, 150 years ago. We don't know. Could have been an old wagon road and at some point it deviated from the section line. Maybe at some points in the past, the section point, the quarter points, the section corners were mislocated. Don't know. This is just how it is right now. And we prefer to build on an existing center line. I think we've told the water district that this will not impact them. In 30 years, they may need to relocate because their tower, their water tank, will be inadequate for the needs in the future. So from a public works standpoint, this is a normal request. We don't think it's excessive. This is a major collector. And for major collectors with open ditches, we have a 90-foot right-of-way, 45 foot on the south side, 45 foot on the north side. So are there any questions? I'd be more than happy to answer those.
Is there 90 feet of dedicated right-of-way along the rest of 46th Street?
I doubt it, not on the south side.
Okay.
But we gotta start somewhere.
Right.
And typically when
Somebody
we replat, we
plats,
request a
then you-
dedication.
Right, yeah, take mark, yeah. They could still operate this proposed gravel road on the right-of-way
On the right of way until some point in the
until
district.
30 years down the road,
Yeah.
you wanna improve it.
Yeah, absolutely.
Yeah.
And if there's a need, like the gentleman said, if there's a need to, at some point, we have to relocate the water line, that's what we have to do. They were there first, so even though we're gonna encompass that area with right-of-way, we would be on the hook to pay them to relocate.
any other questions of the commission? All right. Are there any persons that would like to speak in support of the item, other than those that have spoken already? Are there any persons that would like to speak in opposition? Is there anything else the applicant would like to comment on?
Just a couple of comments there is, one, we're not opposed to give, the 90 foot is a standard right-of-way width. It's just that all that right-of-way being taken from the south side of the road seems unjust. And none, to get the 90-foot right-of-way, none would have to be taken off the north side. And that's gonna happen all the way down along here for every homeowner that's there. I guess the second thing would be is that, I know what Mr. Neal is talking about is that as far as construction of the new road, we understand it's going to be a 3-lane, you know, it's a turn lane. Don't understand why the 3rd lane couldn't just be built on to the north side and not disturb the south side. When you look at the bank profiles and everything, and that would then center, for the most part, center the road back up on the section line. So I don't have anything further than, thank you.
Thank you.
I got one more thing.
All right.
I understand we all gotta live in our budget. You guys, just like we do, we all got a budget we gotta live in. If you look out here on 46th Street, the bank's on the south side, as he was talking about moving this dirt. On the north side it's only a foot or two above the road. There's some of the places on the south side that it's 6, 7 foot above the actual surface of the road. So if we're gonna equal this dirt out and we're gonna scoop these ditches and put most of them on the south side, you're gonna have to move more dirt off the south than you do off of the north. Right at the water tower, the north side is level with the road. And again, we all have to live within our budget. And I know taxes are, you guys hear that, I'm sure, more than I do. And I know you gotta live within what you can bring in, but so does the water district. And you're just kind of hindering some of our service work on our tower. If we put up another tower, it won't be at this location. We'll just add a tower. We've got some other property, and we would just add a tower. I can't see this is our engineer, I can't see this tower ever getting bigger or doing anything, because if you put a bigger tower up, you gotta tear the whole footings and everything out and start over. We would probably move on out farther out into the center of the district and put up another tower out there. So, I mean, as far as reworking the tower, I can't see that ever happening here. Ben could probably tell you more about that, but I can't see us ever reworking this tower. I see us building another tower farther up in the district. And we're just trying to help out 670 families in our corner of the county, and we'll just have to live with what you guys decide. Thanks for letting me talk to you.
Thank you for all your comments. We'll close the public hearing. Commissioners, do you have questions or comments?
From my understanding, nobody else on the south side has granted an easement. So Public Works would have to get easements on everybody on the south side of the road before
Yes.
anything could happen.
Sure, the way that we do that is that when or if a plat happens, those dedications begin. And then beyond that, if there's not dedications already in place, then they would start doing negotiations with owners and eminent domain proceedings and such like that to gain additional right-of-way.
Thank you.
And nothing can be done if the preliminary plat is not approved.
So you're looking at both the preliminary and the final plat right now. The way that we're proposing is with the 45-foot. The way they've asked is with the 25-foot. And so you as the planning commissioners on this have the ability to decide how to move forward. And once you've voted and how to move forward, that's what would be recommended to the Board of County Commissioners for approval. We would probably have a similar discussion with them at that point to see if there's a difference of opinion at the BCC.
How did the replatting come about again? Was that just because of this request?
So this tower, will you go to the one more down? Right here. Okay, so when this tower originally was built eons ago, 70s? 60s? Yeah. They came in and got a conditional use permit from the planning department at that time for this specific site with just the water tower. So they have a conditional use permit right now for a public use facility. When they came in and started talking to us about putting a building, when I go back and look at that site plan, then we see on there that the site plan shows just the water tower, and so they needed to do an amendment of the conditional use permit to put the building on so that they could construct that building. But as we started going down the rabbit hole, what I determined was that they could do an amendment to the conditional use permit site plan as a minor amendment, because it's not constructively changing the use or the what's been permitted as a public use facility. They're still gonna use it for the same exact reason. So my regulations allow me to grant a minor amendment just administratively. If they say, hey, we would like to amend the site plan to add this building, I have the ability to approve that administratively. But when you're looking at the regulations as a whole, this property should have been platted to allow for this water tower to be used to begin with. My assumption is, not knowing the hows and the whys from the 70s, that maybe the plat either wasn't required at that time, or that they didn't require them to plat because the only thing going on the property was a tower. There wasn't going to be people on there, there wasn't going to be, it wasn't gonna be daily use where people were coming in and off of the tower. It was just a tower. And so now that they're adding the building, the use of it is changing a little bit, to the extent that there will occasionally be people coming on, maybe having a meeting occasionally. They'll be storing equipment. There is gonna be a bathroom in there. There will be laterals. So because of that, I felt like it needed to comply with the regulations in regards to platting. Anything less than 3 acres and 200 feet of frontage should be platted for a use like this. And so they're doing the minor amendment site plan, just administratively, but the plat then gets them so that they have a properly platted parcel.
So at this point, if they don't move forward with the building, they're grandfathered in?
As they are right now, yes. They would not, we're not making them make changes to it based on their current use.
But they would not be granting an easement then?
No, but I don't think that there's any question that they're moving forward with the building either way. And we're not trying to prevent them from moving forward with the building. It's just trying to get the plat finalized with the specifics of what needs to be on that plat. And so everything else on the plat has been okay, and everybody's agreed on everything. It's just the matter of the 25 feet versus the 45 feet.
Well, my thought is if this is 45 feet is a big deal, they may want to look to another location to put their building.
What are you gonna do with the building, Riley?
Pardon me?
What are you gonna do with the building?
Is have a little place to store some paperwork in, and we'll store some pipe. We're not gonna store anything outside. Lawnmower, weed eaters, a lot of their pipe fittings and stuff now, we store in the bottom of the water tower. That stuff will all be inside of this building. We're not gonna store anything outside, but I'm getting ready to retire, and they have a lot of that stuff, as you know, Myron, at my house. And get out of here. Whether it's in the ditch up there or it's out of here. But there'll be the lawnmower, there's a lot of records. We store a lot of the records down in the water treatment plant that's down on Humphrey Road. But you gotta climb up on top of the bathroom, and it's carrying boxes up the ladder. And we would really like to put this building up there. They can store some 20-foot joints of pipe in it. We've got a lawnmower, we've got a side-by-side that they use to do their valve exercise work, a generator, just basic tools that'll all be inside of this building. And there'll be a garage door facing the tower where anytime they go in and out of that, they can go through the tower. But to get in the front of the building, they can just drive around the corner. And we go in there now, I mean, I was in there a couple times today, we had a water leak up north, and we have to go in there, but I got the whole bottom of that tower full of fittings, and I don't have any place to store the pipe or the lawnmower or any of that stuff, and that's the point of this little building. We missed a really nice building in Silver Lake, they just bought that and been done,
there won't be that much traffic in and out of it, though. I mean, it'll be,
Not any more than there is now.
yeah, same.
I mean, I go in there and check chlorine residuals, and like, we was in there last week, we had some problems with the telemetry off the tower. And the guys out of Wichita, the Comtronics guys, we were in and out of there 3 or 4 times, but I don't, some weeks I'll go in there every day. Some weeks I don't, sometimes I'll go in there for a month. It just depends on what happens out in the water district. Now, like I said, 90% of our material is in the bottom of that tower. We can't get any pipe in there. We can't get the lawnmower in there. We can't get the trailer in there. But that's what this building, this 30 by 40 building is gonna be, so they can put this stuff inside. And when we hand off to the new guy, here's the storage building, here's where you keep that. Nothing outside, no fuel storage, just. Never say never. I know it scares me to say, this could be 30 years, it could be never. It scares me to have guys on top of the tower, because I know I can get up on, when I'm up on top of the tower working on the lights and stuff up there, if I park my pickup out there outside of that fence, you have to look out over the ball to see it. And if we get anything inside of that fence, if you drop something off the top of that tower and it takes a little bounce, it's gonna be outside the fence. I just don't want the water district to take on an additional liability. I don't want them raising my rate.
All right, any other questions or comments, commissioners? It sounds like we can approve it as it's platted, or approve it with the 25-foot right-of-way.
So the plat
And
right
hope
now
that-
that's in front of you shows just the 25, but the recommendation would be that they would have to adjust that to the 45. So you can approve it as it's drawn up right now, or you approve it based on the recommendations of staff.
I move that we approve it on the recommendations of the staff.
I second.
It's been moved and seconded that we approve the plat based on the recommendations of the staff. Now I've got to get to it.
Okay, so Jeanette Johnson,
I want to look at your recommendations.
Okay.
again. I'm sorry. Get to me last.
the recommendation, she does have them up on the screen as well.
Oh, I see. Okay. So that would be with the 45.
With the 45 feet.
All right. I'll say, no.
No? Dan Bryan,
Yes.
Terry Robinson,
Yes.
Myron,
No.
Rosa Cavazos,
No.
Chad Gearhart.
Yes.
Okay, so you have a split vote, which means that it fails to move forward with a recommendation of the 45 feet. It does still move forward to the BCC on, well, once you have the plat through county surveyor mapping and go through the whole process of getting the Mylar ready, then bring it back to us, then we'll take it to the BCC at that point. So it failed to be approved at 45 feet. What that means is that it does still move forward, but with the 25 feet. Okay?
All right. Everybody understand that?
Very well. Thank you for your time.
Thank you.
You want to pass this down to Joni? All right. Any comments from the public on non-agenda planning and zoning items? All right, discussion of planning-related issues. Next steps for solar regulations. Well, our new members probably haven't necessarily gotten up to speed on where we are.
Okay, so we are going to start looking towards the next steps of our solar regulations. History of where we got where we're at. In 2022, we had a couple of conditional use permits for solar farms that were considered and then approved in May, June, and like September of 2022. As we were going through those conditional use permits, there was a lot of concern by not only the Planning Commission, but some members of the Board of County Commissioners that they didn't really know where to look, what to do, what considerations to take when looking at a solar farm. And so there was a request to my office that we look at doing regulations that set forth some specifics about what a solar farm should look like and what we would want to regulate or not regulate. It started down a path of just doing some research, doing a survey, having some discussions here within the Planning Commission, moving forward to public hearings, talking about moratoriums. 2023, we spent some time talking about moratoriums. We had some presentations by various people, some that were associated with wind and solar companies. Jeremy Goodwin with WIBW presented. A representative came and talked about the downsides of wind and solar. So we got people from all sides to come in and talk to us about whether or not Shawnee County would be good for wind and solar. The next steps were we held a public hearing on a one-year ban. I was directed at that point by the Planning Commission that the Planning Commission was interested in considering a ban on wind and a moratorium on solar. And so we did a public hearing in May 2024 at the Overland Station where that was considered, and both of those items were approved and sent over to the BCC. We then had another public hearing in front of the BCC, and again, the ban was approved and the moratorium on solar was approved. That moratorium is a one-year moratorium. It's a temporary reprieve to give us time to get our act together, figure out what regulations we may or may not want. Do you want regulations? Is it possible that as you look at this, you say, we don't want regulations, we would like to just allow solar if we want to allow solar, and they come to us, and when they come to us, then we consider it at that time. You may decide that you do want regulations, and then the question is, are you going to allow regulations for any type of solar farm or only smaller scale, bigger scale, what kind of considerations on size? There are three types of solar conversion systems that we have considered as a part of this whole process. The first is personal. That supports home and business uses, and we did not put that under the moratorium. If someone comes to us and asks for a building permit for solar panels on their house, we grant that. If a business comes to us, and this did happen with Hills, they put up a small solar farm at their company. So long as it's supporting the home or the business itself, it's okay, they can do it. The other type is limited. Those are either groups or entities that collectively create an area where they put solar into play. That could include a cooperative or a municipality. The two solar farms that we have were done by Free State / Evergy, so those would be considered to fall under this limited. I see limited versus utility scale also in the light of size. While we did not have that in this definition, I think that would be something that you would certainly want to consider, whereby utility may mean something that's very large in scale and limited would be smaller in scale, or either one of them could be large in scale, but you limit it on a size. Utility scale are all situations in which the electricity generated and collected is sold. So whereby limited may be just for a certain group of people, or it may be sold only to a certain group or used by a certain group of people. Utility scale goes into the main grid, and it just gets mixed in with all of the other electricity that's collected and then used by people. So that moratorium that we have should expire at the end of May. And so as this is going through, likely we can get pretty close to where we want to be by May, but I highly doubt that we're going to have something approved. So just in the foreground know that we're probably gonna need to ask for an extension of that moratorium or allow it to expire. If it expires, it doesn't mean that we're in any situation of harm, but if a solar application comes in and we don't have those regulations finished, we would have to go ahead and proceed with that application, even though the regulations are not finished. If you ask for an extension of that moratorium and ask the BCC to extend it, that would just extend the protection of not having an application filed while we're trying to consider these regulations. So procedurally, the recommendations that I am making at this point is that we have no cases set for March, but I would recommend that we set that meeting as a work session. It would allow me to give you some presentations on various topics and issues and allow you to start talking, having discussion amongst yourselves about what it is that you really want to see. As you all know, I sent out a little mini survey form asking you what your input is, and pretty much across the board, it appears as though all of you would like to see solar moving forward. One of the questions I asked, are you wanting something very specific regulated or more generic regulated? And that was kind of split. Some people think that we should have more specific regulations, and other people think we should have more generic regulations. So I would like to really fuss that out and talk about it. Also, I've spent some time reading through regulations of communities surrounding us or within the state of Kansas, and I have at least 2 or 3 examples where it may not be the right fit to just copy it word for word, but maybe we can take chunks of those regulations and put them together to make it something that's good for us. And so we can start working through that. And then my anticipation would be then by maybe April, May timeframe, we would have another work session where I have a draft set that you could review and go over those regulations and then start whittling it down, taking stuff out, making recommendations of things that you want to add. And then at that point, either we could do one of 2 things. We could then go to just having a public meeting, open house for people to come in and talk to you, give input, or we could go straight to taking that draft to a public hearing like we did at Great Overland Station, where you have a presentation of a draft and they give you comment. But then the question is if they give you comments and you want to make changes, then we would have to kind of go back and do some changes. So I think having an open house of sorts would probably be a good idea to get some input from people. At each of the meetings that we hold where there's work sessions, we can have public comment. So anytime you're working on things, if you want to allow public comment, they can absolutely get up and give input. It wouldn't be a back and forth question and answer. It may be you guys have been talking through things, and then at one point there's a time where they can give comments and you can listen to the things that they have to say. I anticipate not until probably June or July or August that you would have a draft for that public hearing. And then, actually I take that back. September have a draft of whatever regulations you have into play in front of the Planning Commission, and then we would move that forward to the BCC October. And that's just the timeline that I'm thinking. Some of this also will stretch out depending on what kind of cases we have filed. If we have a month where we have 4 or 5 cases come up, we may not want to spend any time talking about solar regulations. If we have several months where we don't have a bunch going on, it would be good to get through as much as we can in a short period of time.
How soon could we get the extension
On the moratorium?
on an agenda, yeah?
I don't think that we would need to go prior to May, which means if you have a meeting at the beginning of May and want to make a vote on that, I could take it to the BCC at any meeting thereafter. If you want to vote on it in April, I think we just need to kind of pace it based on what other stuff is set.
I mean, it has to be put on an agenda for the public to see that we're gonna vote on that, right?
We wouldn't have to do it as a public hearing where you have to have the full people in favor of, people in opposition. You would just make the request, direct me to do it and vote on it, and then I would take it to the BCC, and it would be listed as an agenda item on the BCC. I mean, maybe we could get through by the end of May. I just think that isn't logical, especially if we have any big cases come up over the next few months. So that's kind of what I'm thinking. Do you guys have input? suggestions on procedure, what you were thinking you might want to see?
I think I'd be looking forward to the information that you're bringing to us to take a look. And, you know, once we get that, we may have a better idea of what the time frame is. We don't have anybody at this point even thinking about doing a solar farm, do we?
Not that we're aware of.
Yeah.
Yeah.
That could happen
That's the
anytime.
unfortunate thing, is we don't know until we know.
Yeah.
But no, we have not received anything. And so at this stage, the next deadline for any sort of application of anything is the end of February, which would be heard in April.
Okay.
But typically, we would kind of have an idea that it's coming, and we haven't heard of anything.
If we set regulations and then an application comes in after that, can we condition that applicant past the regulations, you know, heavier than the regulations that we've set forth?
That will be something that you would have to consider. Most likely, yes. You do that now on any case. Anytime you hear a rock quarry or a wedding venue or what would be another example of something that a rodeo? If you have something whereby we make recommendations of conditions, you can always add to those conditions. And the same as if there's conditions within the regulations, that's what you do, is add to it if you want.
You said you've been compiling what other jurisdictions or cities or counties have done. When you're talking to your peers, I mean, have you ever asked them for their feedback or recommendations on what has been working, what hasn't been working?
It's all been very similar to what we have. So Douglas County allows large-scale solar farms, and their regulations are very, very extensive. They are regulating a lot. Based on what I have personally seen of that, it's caused a lot of contention, not only because they're allowing solar farms, but they're allowing the large-scale utility solar farms, but then they're doing a lot of regulating in regards to the applicants end up having to hire a lot of third-party experts, because I, as the planning director, I don't know a whole lot about a lot of stuff. And so if you're asking questions about environmental issues or glare or noise, or so that they're putting into place regulations that require various experts to be hired and paid for to do studies and then review those and make recommendations. And so I think to some degree, some locations may over-regulate and put a lot of conditions on. And then there will be other locations that really under-regulate and just don't have a whole lot of anything. And it can be anywhere in that mix, and I don't think that there's any one right way or one right answer. I think it just has to be based on what we feel is best for Shawnee County. So like I mentioned at the beginning, you could walk away and not do any regulations. We could add solar as a use permitted by conditional use permit and then not place any sort of conditions on it. It would allow someone to come in and apply for a conditional use permit for a solar farm, and then depending on what it is, we know it has to be a conditional use permit, but you guys make 100% of the decisions. Now, the downside to that is you don't have really any direction. It hasn't gotten any better than what it was when we did these a couple of years ago. What we've found for something like a rock quarry, there was a rock quarry back in like 10, 15 years ago where it ended up going to court and a bunch of conditions ended up being placed on a rock quarry. There was like 25 conditions. We've ended up taking, anytime those rock quarries or sand quarries come in, we say, well, here's a copy of 25 conditions that we're gonna go ahead and request be added. And so instead of it being part of the regulations, it's just a standard protocol that we add all of them. What you can do is you can put those in the regulations, and then when you consider it and approve it, you just say you have to do everything that's in the regulations. So if you write it all out very specifically, you can easily say you have to do it based on the regulations, or in the alternative, you can have nothing in the regulations or very little, and you can say you have to do it based on the regulations, but then we're gonna add these conditions. And then you can do it on a case-by-case basis depending on the specifics of that case.
Could you remove one of those as well? Like, you know, your rock quarry example, you wrote 25 recommendations for the one out on Valencia, and then somebody else comes in, wants a rock quarry, can you, at that point, under their conditional use permit, say, we'll take out number 3, we don't feel like that applies?
I think it would depend on how we have it written within the regulations. The Board of Zoning Appeals has the authority to grant a variance or an exception from regulations. The Planning Commission does not. Now, does that mean that if there are 25 conditions listed to something that you don't have the authority to give some wiggle room to? I think that the answer is I don't really know the answer to that unless we had kind of a specific example. I think we would want to be careful doing that, because if we've considered those as important to all
Yeah, I just,
situations.
so like that example, I get worried that we have then, you know, tied ourselves to a set of regulations that might not fit.
Yeah,
Might
and
not fit everything, might not fit every, you know, and
so an example of that is with, say, for instance, a bed and breakfast right now. We have a list of conditions that a bed and breakfast has to meet, but it could be that not all of them apply. And so I think in any consideration, here's the list of all the things that you have to meet or consider, but it doesn't mean that necessarily all of them apply. But if you're looking at, say, for instance, you're looking at a solar farm and we've set a regulated setback of 250 feet from a residence, and then you have one come in that's 100 feet from a residence, if you waived that, I think we would not be in a good spot.
Right.
I think you'd all agree that we need some guidelines so that we're treating everybody the same. I mean, even though some guidelines might not apply. I mean, we're not, you know.
I don't know, I'm somewhat of the stance of conditioning them all individually, myself.
Well, that's kind of what we did before with the two that we, you know, we looked at that particular,
Were you were on the commission for
yes.
those two, right?
And it made everybody kind of uncomfortable that we didn't have anything to go by.
Yeah.
Which I think is my question. Is it something that we can have some solar expert come in and educate us on that? I mean, we're making regulations about stuff we don't know, or is that up to us to educate ourselves in regards to the ins and outs of solar?
Yeah. So, yes, we could attempt to find someone. The problem being is that there's no federal or like group directive on what is right and what is wrong. For everything that someone tells you is okay, there's going to be someone else that tells you is not okay. I think where we could try and get some direction, my recommendation would be that we try and not only create our regulations, but then bounce them off of input from people who have some work in that area. Chris Carey would be an example of someone who was the person who brought the 2 solar farm regulations for Evergy. He is a geologist, he knows a lot about a lot, and has worked on solar farms, so maybe he would have, and he said, he was like, I was very involved in some stuff in Douglas County, and he's like, I can tell you things that don't work and things that do work, and he is, you know, I don't know if he's working on the one in Douglas County now, but I know that he has had input on that. Another, we had comment from an engineer when we were doing this whole process. Eli May is an engineer with one of the companies here in Topeka, and he has a history and a background with wind and solar, and he works for SBB or one. He works for one of the engineering companies, but he came on a personal level. We could send something to him and say, hey, what do you think about these? What are your gives and takes?
Wasn't he with Bartlett West?
Maybe so. I don't remember.
I remember that now.
Yeah.
Yeah.
And so we could reach out to him and ask for input, or Josh Spotty, who came and talked to us, who represents wind and solar companies. He may have good input. So there are people we can reach out to. I think that the question of who's an expert on it is, it can go either way.
And I think you'll want to think about, I mean, when you say expert, are you thinking environmental impact, or are you thinking actual construction? How far do we want the setbacks? What do we want this thing to look like? And sort of pick your topics, and that would narrow it down for us. I mean, what are you genuinely interested in learning about? Would be a suggestion that I would have. I mean, we can find environmental impact experts, but I don't know that that's gonna help you draft zoning regulations, if that makes sense.
Like setbacks, for instance, that's one that I always think doesn't need to be the same for every case.
Well, and so in that situation, you could set a minimum, whereby you have a minimum, and then based on a circumstance of a specific case, if you wanted to exceed that, in the regulation, it could say you have to have a minimum of so many feet from a residence or so many feet from a property line, and then with considerations of various issues, you may want to enhance that to additional.
Well, I think there's just a lot of information. I mean, you bring up environmental factors, you say, maybe that's not what we're interested in, but, the question is, a 25-acre farm and, in lieu of a 100-acre farm, what are the pluses and minuses from every kind of an aspect? I think we would, even if we decided that we would figure it out at the time, I still think we want to know what kind of impact, based on the size, based on maybe even the kind of solar panels,
Yeah, and you can, definitely, when you're considering, you could require them to provide, I mean, part of it could be that they have to provide a certain report that shows certain impacts, whatever those, whether it be environmental or road or whatever they may be, we can ask that they have to hire an independent inspector or engineer or third party, and then that has to be provided to you to consider.
The newer commissioners may not know that you put on the website a bunch of information from other counties. And that-
So we have on the website, mainly I just have stuff that was heard at the public hearings, but we do have a Dropbox that I sent to each of you that has links to Kyle's, when he did his presentation, it has like his PowerPoint, Josh Spotty's, Jeremy Goodwin's. It has copies of PDF regulations from Coffee County, Butler County, Pot County, and I think one other. So there are some out there if you want to open them and read. But I mean, that's up to you if you're going to go out and read them ahead of time before coming back the next time. Harvey County was another one. My thought is I will probably go and start cutting and taking from certain ones and, looking at what each of them did. What did each of them regulate? And are there good ideas? And, on one county, they only put 100-foot setback, and on another county, they put a 1,300-foot setback. And so, we can cut and paste and leave kind of blanks. Like, here's an outline of what it is that we want to look at, and then fill in those blanks.
Have you had any conversations with anyone in Jackson County about what's going on up there?
Not Jackson County, no. I've read through some of the stuff that's going on out there right now, but I haven't had any communication with their planning staff.
It's gotten pretty messy up there.
Yeah.
Federal lawsuit now as
Yep.
well.
Yeah, I read through the federal lawsuit and, yes.
We probably want to avoid that.
We want to avoid any
Yeah.
lawsuits if we can. We would like that. They also have, the difference being, we have a moratorium in place and we do not have a pending application. They, while they're trying to do their regulations, have either a pending application or a lot of leases with the anticipation that that application is coming. And so we have that benefit of the moratorium that kind of gives us that little extra layer of protection.
Do you know if there's been that activity in Shawnee County of purchasing leases on property? Do you have any heads up on that?
No, we haven't, we did with wind, we heard that there were wind leases, but I have not heard anything about solar. But, I mean, it's not to say, I also didn't know for 5 years that there were wind leases out there before it started coming up as a
Do they
topic.
not file a memo at least with the Register of Deeds?
They might, but it doesn't, we don't get that unless we go search for it.
So are you wanting us to go
You-
with your recommendation here?
Just, kind of, we're here for discussion. I wanted to bring up the topic again, and my recommendation to you would be that we meet in March and we really start hashing out some of the specifics of, going from Chad's direction of, let's allow solar farms as a conditional use permit, but we decide it on a case-by-case basis, all the way to the end of, Jeanette's, let's lay it out there, Terry's, let's get some good regulations, and I wanna see reports. We can start laying specifics so that I can start putting something together. That would be my recommendation for procedure. Above and beyond that, I think, as, mentioned, we're gonna have to just kind of play it out as it goes.
So at this point, there are no applications?
No. And even if we received one, we would turn it away because of the moratorium.
Okay.
Yeah.
So, I mean I mean any applications for anything?
No, sorry. no.
Okay, so we can have a work session,
Mhm.
but it would not necessarily be a public
We
work
would do it
session,
as,
or?
we would still have it as a public session.
Okay,
A public session, a work session, people can still come and sit and listen, but it doesn't necessarily mean that they get to participate.
okay. Because it's a work session, not a public hearing?
Yeah.
Okay. As long as we make that clear, I think.
So the next couple of things, I did list some considerations about just what we've all discussed. I'm not gonna go over it again. These are, ideas of things that we could consider in regulations, and we can talk about that more next month. One thing to have on your scope is that we have had a couple of inquiries on battery storage facilities. When we did, we have no applications, but we've had inquiries. Now, when we did the wind and solar, battery storage facilities associated with a wind or a solar farm would either A, be banned, or B, be under a moratorium. But these that have come to us are standalone battery storage facilities, and so they are sort of like the third apple on the tree. You've got wind, you've got solar, you've got battery. We didn't talk about it, we didn't consider it, it had not been a topic that had come up here, but I've had at least 3, if not 4, inquiries on battery storage facilities. And so one thing that we may need to consider is whether we need to, if you want to regulate battery storage, just like we're talking now with solar, and then the potential on whether or not we would want to do a moratorium. Now, with battery storage as an independent standalone facility, most likely for it to work, they would have to apply to get on the grid. It's not like a solar farm that just feeds you can have battery storage that feeds your own house or your own solar panels, but they would have to apply to get onto the grid, and so we're talking like a probably 2-year application process that they take to do that. I don't anticipate any immediate action for a battery storage facility, but just have it on your radar.
With that, we've got a moratorium on battery storage associated with a solar installation inside of our county. Could the solar installation in Jackson County get approved and that battery storage be in Shawnee County as a standalone like you're talking about?
Battery storage standalone facilities can go anywhere close to,
Yeah.
I believe,
Do you
close
think
to a
any of the-
transmission line.
Do you think any of the inquiries that you've had so far have to do with that?
It's hard to say. They're never gonna tell us that it's associated with wind or solar because it's standalone, and because once the electricity from a solar farm or a wind farm gets into the grid, it all meshes with all the other electricity that's brought in from all the other collection methods. So there's no way for us to differentiate that unless it's directly connected to the solar where it's getting brought
Yeah,
into
it's
the
coming
solar
off
and
the
then
solar
into a
straight
battery
into the
storage.
Yeah. Which is potentially, there could be potential for that to happen close enough with the Jackson County solar farm to have it across the line in Shawnee.
So something to think about.
So what's your recommendation to get ahead of that?
We could do it similar to what we did with wind and solar, either consider a moratorium, or as we're working on solar regulations and then the zoning regulations, also consider some level of battery storage.
Sounds like we need to add it to the moratorium, if you hear the inquiries.
That's what it feels like to me too.
Yeah.
At least for the time being.
Problem being is that we probably would need to have a public hearing on it, like we did with wind and solar. We set a standard for how we did it, and so we would probably want to have it as a topic, have a public hearing, allow comments pro and against before you voted, and then make a recommendation to the BCC like we did with the other two, so. Last topic was I was gonna talk about zoning amendments, but frankly, I'm not ready for that yet. So let's focus on solar for the next month or so, and then just, again, have it on your radar. We've, 2 years ago, well, in 2022, the zoning amendments to our regulations was on the hot plate, and that's really what we were gonna work on when I took over as the director. I put it on a standstill because we just didn't have the time or capacity to handle it. And it's gonna have to come back around. We need to make some changes to our zoning regulations, so this is my year of regulations, and I would like to start moving forward with it. So you guys are the lucky panel.
All right. If there's no further business, then we'll adjourn the meeting.